Good morning, everyone. Thank you for joining us this morning. Today's presentation, it's geared towards creative workers and knowing your labor rights that exist. So I will switch over. So today's presentation is going to be presented by myself. So my name is Miguel Campos. I am the director for the City of Chicago's Office of Labor Standards, which is a division of the Department of Business Affairs and Consumer Protection. And I go by he, him, and I'll now introduce Richard Ruff, who's with our office as well. You're on mute, Richard.
So my name is Richard Ruff. I'm a supervisor with the City of Chicago's Office of Labor Standards, and I go by he, him, and I will introduce Amanda Carlson.
Hi, everyone. It's nice to be with you this morning. My name is Amanda Carlson, and my pronouns are she, her, and I'm a senior strategist here at DCASE. I will popcorn it over to Laura.
Hello, everyone. My name is Laura Trejo-Lozano. I use she, her pronouns, and I'm Program Director for Cultural Resources at DCASE, the city's Department of Cultural Affairs and Special Events. I will now turn it over to Ganapathy.
Hi, my name is Ganapathy Ramaswamy. I go by he, him. I'm the Deputy Chief Legal Counsel at the Illinois Department of Labor. Thank you.
So we have a lot of ground to cover together over the next hour. The webinar was posted for 90 minutes. Our presentation will last around 50 minutes, and then we'll turn it over to Q&A. And for those who can stay on and to have your questions answered, we'll go into those. But for those who can only stay an hour, we will try to get things mostly wrapped by 11 o'clock. But while we are together today, we will dive into some context on the campaign, where it came from, some definitions around creative work, and the labor laws that we'll be discussing. We'll have an introduction to classification and misclassification from Miguel. And that's the how to tell if the work you're doing is that of an employee or that of an independent contractor, and what to do if you think you're being misclassified. Then we'll pop into an introduction to Illinois' newest law around freelance workers' protections. And then we'll head into a deep dive on the range of Chicago labor laws. Miguel will walk us through that before we turn things back to Laura to talk about resources and head into the Q&A. So as was mentioned at the very beginning of the call, please use the Q&A box as we go over things. And we'll respond to questions in real time, as well as hold any that may take longer discussion for the end. Next slide, please. So to dive into an introduction to the Creative Worker Rights Art is Labor campaign, an important place to start is with DCASE's mission, and that is to support artists and cultural organizations, invest in the creative economy, and expand access and participation in the arts throughout Chicago's 77 neighborhoods. In order to truly value arts, culture, and creativity and what it does for our city and our society, we need to make sure that the people behind it are supported and able to thrive. That's how DCASE is coming to this work. And we are so thrilled to be able to partner with BACP and the Office of Labor Standards, whose mission is really around ensuring worker protections in the city of Chicago. So this campaign is a multi-department collaboration here at the city. Obviously, we're also partnering with the state to share information, but it isn't coming out of thin air. And really, it's a progression of years of work and advocacy, both locally and nationally, to bring conversations about the conditions of creative work into the city while supporting that broader dialogue. We know that there are advocates, organizations, others, artists, those of you on the line today who have really been talking about what Chicago's creative workforce needs and what supports are required to improve labor conditions and practices. But when we heard from our partners, we heard that like a starting point for this work should be around education and awareness. And this comes through recommendations made through recent planning initiatives, through mayoral priorities, and the transition work that was happening over the recent years. If you go to the Creative Work website, which is chicago.gov/creative work, there's a subpage that has background information, which includes links to the research, the plans that are the foundation for this campaign. But again, to the advocates and individuals who have been working on this for a long time, we wanted to fold that awareness and knowledge into how this campaign was shaped. And so we convened an advisory committee during April of 11 members of the sector, many from organizations and entities that have connections to individual artists and independent workers to shape the resources that we were going to provide and the way that this campaign rolled out. And it's under their guidance and feedback that we are continuing to build this campaign and this work. And this is a starting point for DCASE and BACP, and more will be happening over the months come in 2024 to really flesh out the resources that are available to all of you and the sector as independent workers and as employers of creative workers. Finally, we were joined in this work by Public Communications Incorporated that helped us build the visual assets that you'll see out in the world and through the campaign. Before I move forward to the next slide, I see that there's one hand raised. If you have a question, please feel free to throw it into the Q&A box. Next slide, please. So today we're here at this webinar focused on creative workers, and the definition of creative work for the campaign is intentionally expansive. I won't read everything on the slide because this entire deck will be shared with you after the call today. But I'll simplify what's there to say that when we talk about creative work, we're talking about all of the jobs that are within the creative sector, whether that's at an arts and culture nonprofit, a for-profit business, jobs that are created through collaborations that are made by individuals who just want to work together and are interested in building things, collectives. And we're talking about large organizations and individuals and all of the people that ensure that arts and culture within our city can thrive. That includes the administrators, the security personnel, the educators, everybody who's making it work. Outside of that, those kind of more traditional kind of like work, jobs or independent contractor roles, we're also talking about creative production through grants, residencies, and fellowships. It's expansive, and that world of creative work doesn't stop at the boundaries only of the arts and culture sector. We're also talking about the artists and creative professionals that are working in other fields, and the resources that are being developed through this are intended to speak to all of those audiences. So we're talking about all of those different types of work, as well as all of the structures of employee, independent contracting, freelance work, and those who are also working as entrepreneurs or sole proprietors. Next slide, please. So this slide is a bit of a sight gag, but hopefully it drives home the point that when we're talking about creative work, we are talking about it across its breadth. We heard repeatedly, not only in the calls to DCASE to begin to think about this, but also from our advisory committee, but that it was important that people know that the resources and information provided through this campaign is for them, from art directors to business managers to percussionists to stagehands to technical writers to cultural producers. Anyone who is interacting with this webinar, the website, things that will come out as we move forward, that these resources are for you, and that we hope that you will connect with us, the city agencies that are here, the state agencies that are here, and also our organizational partners on the topics that we're advancing to talk about creative work and improving the conditions of labor within the city of Chicago. So to get to the labor definitions, I'll pass it back to Miguel.
Thank you, Amanda. Before I get going, I do want to make a couple of reminders, and we don't want to sound repetitive. So to start off with, this morning's presentation is being recorded and it will be made available on BACP's YouTube channel, which is youtube.com/Chicago BACP. And I also want to remind people that if you have any questions, to please use the Q&A functionality. I know we are going to cover a lot of material this morning. We will email a copy of today's presentation deck to everyone who has attended this morning or everyone who registered. And then I do want to point out that the PDF that you'll receive of today's presentation, any links that are contained within the presentation will be clickable on the PDF, so there'll be live links. With that being said, I'll start providing or defining common definitions for labor protections. So this is with regards to the city's labor protections. So when we say an employee, we mean an individual that performs work for an employer in the capacity of an employee as distinguished from a contractor determined to the IRS guidelines. An employer means a person who gainfully employs at least one employee, again, in the capacity of an employee and not an independent contractor. When we say an independent contractor, we refer to an individual that has the right to control or direct only the result of the work and not what will be done and how it will be done. And when we mention a worker, for our purposes, it means either an employee or a contractor, again, determined pursuant to IRS guidelines. A worker or a contractor, we will use interconnected, the term independent contractor. So if we use the word contractor, we mean what's commonly referred as an independent contractor. So in essence, are you a W-2 employee or do you receive a 1099 as an independent contractor? There are correlations or protections from existing labor protections that apply to both employees and independent contractors, and then some that only apply to employees. So on the right-hand side of your screen, you see examples of what we mean by a covered employee. So a covered employee can be anyone who's working full-time, part-time, on a temporary basis, on a seasonal basis, someone working remotely from their home, and then all domestic workers. And then some common examples of an employer might be a corporation, a sole proprietor, a partnership, a not-for-profit corporation, a city sister agency, such as the Chicago Park District, Chicago Public Libraries, or our city colleges, and then anyone who employs domestic workers. So what laws apply and who do they apply to? So if you are an independent worker or a contractor, the Illinois Freelance Worker Protection Act, which Ganapati will speak on in a few minutes, applies to you. If you are either a worker or an independent contractor and an employee, the state and federal classification and misclassification laws apply to you. You are eligible for protections under the Chicago Wage Theft Ordinance, the Chicago anti-retaliation provisions, and most of our laws, and then also of importance, Chicago discrimination and harassment ordinances. If you are an employee, again, someone who's a W-2 employee, then there's additional protections being offered to you by the city, and this includes Chicago minimum wage, access to Chicago paid leave and paid sick leave, and then the Chicago Fair Workweek Ordinance. So we will move on to chapter 2, when I will dive into classifying workers as employees or independent contractors. So who dictates whether an individual is classified correctly or misclassified? So the Office of Labor Standards the state of Illinois Department of Labor, the Internal Revenue Service, and the US Department of Labor, along with the FTC, all have ways to evaluate and enforce the appropriate classification of workers. So in Illinois, the state has what they call the ABC test. So according to state law, an employee includes any worker who performs work for an employer unless that worker is a bona fide independent contractor. So in order to be a bona fide independent contractor, that individual has to be free from control and direction over the performance of their work. They have to perform work which is either outside the usual course of business or is performed outside of all the places of business of the employer, unless the employer is in the business of contracting with third parties for the placement of employees, and then is partaking in an independently established trade, occupation, profession, or business. So I do want to point that there's an emphasis added on this section. So this is under the Illinois Wage Payment and Collection Act, which is a state law. The Internal Revenue Service provides resources to help individuals if they are independent contractors or employees. This orange underlined link where that reads Internal Revenue Service is a clickable link that will be available on the copy of the deck that will be provided to everyone who registered for today's webinar. So the general rule is that an individual is an independent contractor if they have the right to control or direct only the result of the work and not what will be done and how it will be done. You are not an independent contractor if you perform services that can be controlled by an employer, what will be done, how it will be done. This applies even if you're given freedom of action. What matters is that the employer has the legal right to control the details of how services are performed. So this is under the IRS guidelines. The US Department of Labor provides the following chart to help individuals determine if they are independent contractors or employees. So on your screen, you see 6 different categories. And there's a left-hand side, which indicates that you are an employee, or the right-hand side, which indicates that you are an independent contractor. So do you work for someone else's business? Are you in business for yourself? Do you generally, you can only earn more by working additional hours? Do you have an ability to increase your personal profit through a business decision that you make on your own? Do you work for a single employer or do you work with multiple clients? Do you provide your own materials, tools, and equipment, or does the employer provide material, tools, and equipment? Is it a temporary relationship until a project is completed, or are you continuing or to have a relationship with the employer even if it's indefinite? Does the employer decide how and when the work gets performed, or do you get to decide how and when work gets performed? And then who assigns the work? And then do you have an ability to dictate or decide what projects you're going to take on? So these are general concepts. All relevant facts about the work relationship are considered depending on what agency you're dealing with. And then the existence or absence of any particular fact does not require a particular outcome. So in other words, we deal with classification and misclassification on a case-by-case basis. So it's going to be highly dependent on the facts that apply to the relationship that you have with this project that you're working on. So a common example is like you can be a web developer. You're designing websites for different companies. You're going to use the same type of equipment. You're using software, you're coding, you're using a computer. But if you're doing it for yourself, then you might have like 10 to 12 clients and you're developing and maintaining websites. You get to set your own rate. You work at your own pace. However, like I work for the city of Chicago. The city can hire you, pay you an hourly wage to do the same thing, develop a website, maintain it, do coding. You're using the same software, you're using the same equipment, a computer. However, your employer is setting your work schedule, setting your rate of pay, and giving you assignments to complete with deadlines. So it's the same job that's being conducted, and it's just a matter of these other factors that we would apply to determine whether you are an employee or an independent contractor. I will now turn the presentation over to Ganapathy, who will provide information on the Illinois Freelance Worker Protection Act.
Thanks, Miguel. I just want to offer a disclaimer. I'm an attorney with the Illinois Department of Labor, so I can't offer legal advice, but I will definitely try to answer as many questions as possible generally and point to any resources available. So, thanks, Miguel. The Illinois Freelance Worker Protection Act, what is it? It's a new law that went into effect on July 1st, 2024, and it provides protections for freelance worker in Illinois. Under the law, freelance workers are entitled to all the following: a written contract that includes name and contact information of both the hiring entity and the freelance worker. Hiring entity would be the freelance worker's client, person that hires the freelance worker, an itemization of products and services, rate and method of compensation, date of compensation due, and dates of services to be provided. So basically, a freelance worker, in order to get protected under this act, or all freelance worker agreements, must have this written contract. The full payment of services by are due, will have a specified due date in the contract, or if there's no due date, if no due date is specified, then payment must be made within 30 days of completing the services outlined in the contract. In addition, the Freelance Worker Protection Act provides for a protection against retaliation or any other negative action if a freelance worker exercises rights under the act. So who's considered a freelance worker under the law? A freelance worker must meet all of the following criteria under the law in order to gain protection under this act. So they must be considered an independent contractor, and Miguel did an amazing job of sort of outlining the differences between an employee and an independent contractor. They must be providing products or services in Illinois or work for a hiring entity located in Illinois, and the value of work equal to or greater than must be equal to or greater than $500 over a 120-day period. Now, this can be over one contract or multiple contracts, but must be greater than or equal to $500 over a 120-day period. When does it apply? It applies to contracts taking effect after July 1st, 2024. So anything that's starting after July 1st. What tools are available? So on our website right now, we have FAQs to answer hopefully all of your questions. We also have sample contracts available in 11 languages as required by the statute, and it's on our website. We also have a complaint form available. So in the law, there is a process to file a complaint if you believe that the hiring entity has violated your rights, have paid you, or, for example, if you believe that you're entitled to, they're not signing the contract, and you're providing services, whatever. If you believe that your rights are being violated, you can file a complaint form, and then the law outlines procedural steps that can be that'll be followed with the department. Also, the law does provide a private right of action where you can go to court and file a lawsuit against a hiring entity, and does provide for some pretty strong punitive or pretty strong damages that are available to freelance workers that didn't exist before. If you have any questions, We do have an email address set up, dol.freelance@illinois.gov, that is being monitored. So feel free to send questions to that email address regarding anything regarding freelance worker, questions, how the law applies, if you want to file a complaint, if you have questions about the sample model contract, we'll be happy to answer them. As many of you are aware, the Department of Labor does enforce, or maybe you're not aware, we do enforce 30 laws in the state of Illinois, everything from Paid Leave for All Workers Act to the Illinois Wage Payment and Collection Act, minimum wage overtime. Many of these would be focused more on the employees and not necessarily independent contractors. Just so many of you are aware, one of the new requirements that's coming January 1st, 2025, employers with at least 15 employees will be required to include the pay scale on any job posting. So this is the new Pay Transparency Act under the Pay Transparency requirements under the Equal Pay Act, and that's happening on January 1st. So job postings will have to have a pay scale on the posting. So we're busy right now implementing this law, getting ready to make folks aware of this requirement. And how to file a complaint with the state. As many of you may or may not be aware, the Department of Labor does have several divisions. We do enforce 30 laws. We do have a conciliation mediation division. There is an employee classification section. It's mainly for those in the construction industry. So if any of you are in the construction industry where you're being misclassified as an independent contractor, we do have a process to file a complaint. We have a Fair Labor Standards division. Again, if you are not receiving wages or any type of underpayment or you're not getting your wages, and you believe you should be considered an employee and not an independent contractor, there is a process in place to file a complaint with our Fair Labor Standards division. If there are safety or hazard issues at where you work, we have an OSHA division, and then we have a brand new leave rights division where certain eligible employees can get paid leave under the new Paid Leave for All Workers Act. And then we have partnered with DocuSign to make filing complaints easier and electronically. So when these slides become available, you can hit this link to make it easier, or click on a link to make it easier to file a complaint.
Thank you, Ganapati. So the next chapter will focus on Chicago labor laws. So existing protections that exist for both workers in some instances, and then for employees and other instances. So to start off with, this chapter or this portion of the presentation is intended to offer general guidance on Chicago's labor protection ordinances. Just like Ganapati, we are not able to provide legal advice, and then we would request that employers should consult their own legal counsel to determine any actions that they should or shouldn't take in order to comply with the ordinances. That being said, or those disclaimers being stated, the mission of our office is to promote and enforce Chicago's labor laws. We have a minimum wage ordinance. We have a brand new paid leave and paid sick and safe leave ordinance that went into effect on July 1st of 2024. So a couple of weeks ago. We have a Fair Workweek ordinance. We have a wage theft ordinance. The wage theft ordinance covers all workers. So regardless of whether you are an employee or an independent contractor, there are anti-retaliation provisions that are written into each of the ordinances or laws that I just mentioned. And then finally, but not least, we have a domestic worker contract requirement ordinance. And then on the next slide, I am going to provide a little bit more detailed information on Chicago's labor laws. So we will start with minimum wage. So minimum wage increases in the city every July 1st. So we have a standard employer rate. So that would be if you guys work for any employer with 4 or more employees. As of a couple of weeks ago, the minimum wage rose to $16.20 an hour. A youth worker in this slide of this presentation refers to someone aged 16 to 24 who is working for a program that is partially subsidized by government funding. So I do want to point that out, that this is the youth workers that we are referring to in this chart. And then tipped workers, we have tipped wage credit in the city. It is going to decrease over the next 5 years. So the first decrease occurred this past July 1st. We'll go into details in a little bit on the next slide. But minimum wage for a tipped employee at the moment in the city stands at $11.02. And then those youth subsidized employment programs, that wage is $10.20. On the second line of the chart, you see the overtime minimum wage, which is just a time, it's set at 1.5% or 1.5 times the standard rate. So if you work for an employer with 4 or more employees, your overtime minimum wage should be at least $24.30. Minimum wage in the city applies to any employee who works at least 2 hours within any 2-week period. All domestic workers have to make at least $16.20, regardless of whether you are an employee or an independent contractor. Most individuals or households that are dealing with domestic workers are hiring individual persons. So for those of you who may work as, for example, a caregiver or a nanny, your employer should be paying you at least $16.20, even if you get a 1099 form from them at the end of the year. As a reminder, if the tipped wages plus tips do not equal the minimum wage, then your employer has to make up the difference. So your base rate would be $11.02. If you do not make at least $5.18 in tips during 1 hour of work, then your employer would have to make up the difference once they add your tips to your standard rate. If you happen to work for an employer that has less than 4 employees, so 1, 2, or 3, then the minimum wage that would apply to you would be the state minimum wage, which is $14 as of this past January 1st. I mentioned the tipped wage credit. So in October of 2023, the Chicago City Council passed an ordinance which is going to phase out the tipped wage credit. So beginning July 1st, 2024, a couple of weeks ago, the city started on a 5-year phase out. The tipped wage credit was 40%, and it'll reduce by 8% every July 1st over the next 5 years. Here you see a detailed plan of how that will occur. So what this means is that come July 1st of 2028, tipped workers will be making whatever the full Chicago minimum wage is on that date, and there will no longer be a tipped wage credit. For more information on the tipped wage credit, you will be able to click the orange underlined link that says follow this link once you have a copy of today's presentation. I'll talk a little bit about paid leave and paid sick and safe leave. So what does it provide and who does it cover? The ordinance guarantees up to 5 days of paid leave and 5 days of paid sick leave for most of Chicago's workers. So in order to qualify for paid leave and paid sick leave, you would have to be working in the capacity of an employee and work at least 80 hours for an employer within any 120-day period, while physically present within the geographic boundaries of the city. So what do we mean when we use terms or use the terms paid leave and paid sick leave? So paid leave is time that is provided by an employer and can be used for any reason of the employee's choosing, and it is not paid sick leave. As an employee, you are not required to provide your employer with a reason to use your paid leave, and you may not be required to provide documentation as proof of use or in support of the use of paid leave. Paid sick leave is time that is provided by an employer that can be used to recover from an illness, take care of a family member, address domestic violence situations and public health emergencies. And then an employer is able to request documentation or certification only after the employee uses paid sick leave for 3 consecutive work days or more. The city had an existing paid sick leave ordinance that had been in place since July 1st of 2017. And then in December of last year, the city passed the paid leave and paid sick leave ordinance, essentially doubling the time off that an employee would have access to. So under the old paid sick leave ordinance, you just had up to 40 hours or 5 days. So that's when we say 5 days, that we mean 40 hours in your typical 8-hour workday, but it's up to 40 hours of paid sick leave. Under the old ordinance, and then under the new ordinance, now you get paid leave in addition to paid sick leave. The link on this page is going to be super informative and helpful to all of you. We do not have the time this morning to dive into detail into paid leave and paid sick leave, but we have an abundance of outreach and educational resource materials. There are model policies for employers. There is a detailed like FAQ document that's available in English and Spanish. There is, if you're an employer who happens to be attending today's webinar, there's a checklist that's available of what your policies should include, what documentation you should be seeking, what needs to be posted at your place of business. And then there are detailed fact sheets. So there is like a 4-page detailed fact sheet that contains additional information on paid leave and paid sick leave. Accrual rate is time front-loaded. It covers carryover provisions, payout provisions, what pre-approval processes. All of this information is available by visiting the link that's on this page that you guys will be able to click on. And that information at the moment is available in English and Spanish and Polish and Korean and Mandarin and Tagalog, Thai and Vietnamese. And then we have the capacity as a government agency to provide that material in additional languages if we get a request. Again, this is the newest ordinance that the city is enforcing. In addition to today's webinar, we've held 8 webinars that dive into much greater detail into paid leave and paid sick leave. All of those webinars are available for viewing at the department's YouTube channel. Next, I will talk about our Fair Workweek ordinance. What we will start with, what industries does this apply to? So if you are working in building services, healthcare, hotels, manufacturing, restaurants, retail, or warehouse services, you have additional rights depending on the size of the employer. So one, this only covers employees and not independent contractors. The employee must perform the work in Chicago. And then there are salary and hourly floors or ceilings that are met. So in order to qualify for protections under this ordinance, you must make $61,149.35 or less a year, or make $31.85 an hour or less. And then you must work for an employer that's in one of the 7 covered industries. And then that employer needs to have 100 or more employees, and 50 of those have to be covered employees. So what rights are provided under the Fair Workweek ordinance? So before you start working for one of these employers, you are to receive an initial estimate of the days and hours that will be provided to you. You are to receive notice of any schedule changes. So you must get your work schedule at least 14 days in advance so that you're able to plan the rest of your life around work. You have a right to decline any unscheduled hours that are offered with less than 14 days advance notice. You may have access to predictability pay for unscheduled or canceled work hours. If a shift is canceled or hours are reduced with less than 24 hours notice, then you may be entitled to up to 50% of pay for those canceled hours. You have a right to rest. So you have an option to decline any hours that are scheduled within 10 hours of the previous day's shift ending. If you do decide to work with less than 10 hours of rest, and you're in one of these covered industries and meet the definition of a covered employee, then you are entitled to 1.25% pay for the entirety of that shift, which begins within 10 hours of the end of the previous day's shift. This is a complicated and technical ordinance, so I do advise those of you who want additional information to, once again, I sound like a broken record, but please click on the underlined orange link, and it'll take you directly to a website page that contains additional information on Chicago's Fair Workweek ordinance. Next, we'll talk about wage theft. So wage theft, the wage theft ordinance was amended in December. This covers all workers. So regardless of whether you are an employee or a contractor or an independent contractor. So wage theft is the failure to pay workers full wages to which they are legally entitled to. And then on your screen, there are some common examples of what may be considered wage theft. So obviously a minimum wage violation, so paying less than the established legal minimum wage. Overtime violation, so failure to pay non-exempt employees time and a half for hours worked in excess of 40 hours per week. Asking an employee to work off the clock before or after their shift ends. Meal break violation, so denying workers their legal meal breaks. That would be something that we would be referring to the Illinois Department of Labor. The meal breaks are guaranteed under the 1 Day and 7 Rest Act. Any pay stub or illegal deductions, tipped minimum wage violation, so confiscating tips from workers, or failure to pay tipped workers the difference between their tips and the legal minimum wage. And then we started this morning's presentation talking about misclassification. So that can be considered a form of wage theft. So misclassifying employees as independent contractors in order to pay them a lower wage than the legal minimum. And again, we deal with misclassification cases or complaints on a one-on-one basis. There is no one set way that can apply to all misclassification cases. Like with the previous laws, there's detailed information on the City of Chicago's Office of Labor Standards website, and you'll be able to access it by clicking on that particular link once you have the presentation in your hands. Complaints and investigations. So what is it that the Office of Labor Standards can do? So one, as an employee, you are able to file a complaint either online or by mail, or you can call 311 or use the city's mobile Shy 311 app. Resources are also available on our OLS website. So after a complaint gets filed, we will conduct an intake or triage interview. We'll review the complaint, contact the complainants, gather additional information that you may have. If necessary, we can start an investigation and issue subpoenas to require or request records from an employer to try to prove up the allegation. And then we can enter into settlement agreements or file something with the Department of Administrative Hearings, the mayor's licensing division, or at circuit court if necessary. The bottom of your screen, or the bottom of this current screen, under the resources tab, you can see that lovely yellow and red arrow pointing to how to file a complaint. On the right-hand side, these are some overarching figures for January through December of 2023. Our office received over 600 complaints. We were able to close out over 400 of them. And then last year, we were able to obtain $430,000 plus in restitution that went back to directly to workers and wages that were owed. I will now briefly discuss the Chicago Commission on Human Relations. So who is CCHR? The Commission on Human Relations promotes appreciation of Chicago's diversity and works to eliminate prejudice and discrimination. Commissioners, advisory councils, and staff conduct proactive programs of education, intervention, and constituency building to discourage bigotry and bring people from different groups together. So in essence, the Chicago Commission on Human Relations enforces the Chicago Human Rights Ordinance and then the Chicago Fair Housing Ordinance. These ordinances apply to all citizens, all workers, so regardless of whether you are an employee or an independent contractor. These two ordinances that I mentioned prohibit discrimination within the city and the areas of housing, employment, credit transactions, bonding, and public accommodations. What actions can the commission take? So the commission investigates discrimination complaints, and then if there is substantial evidence of a violation, the commission conducts an administrative hearing, issues a ruling that can lead to the imposition of fines, damages, or injunctive relief if a violation was proved. The commission also implements the hate crimes ordinance by monitoring hate crimes in the city and aiding victims. I do want to point out that any complaint must be filed within 365 days of the alleged discrimination. Prevalent complainants, so if you're successful in proving up your complaint, may be eligible to receive out-of-pocket damages, emotional distress damages, injunctive relief, any attorney fees and costs, and in some cases, punitive damages. The respondent or the person engaging in the discriminatory behavior may also be found liable and pay a fine to the city. For more information, you can follow the link once you have the presentation in your hands. And then this is how the website looks for CCHR. So you can see examples of flyers that are available. So a flyer on sexual harassment, a flyer on gender identity discrimination, a flyer on employment discrimination. So if you go on the website by following the link and then go to the section where the arrow is pointing, you'll see educational flyers that'll provide more information on what it is that the Commission on Human Relations does in the city, as well as a copy of the 2024 Hate Crimes and Hate Incidents Report that gets published every June by the office. The next chapter is going to focus on resources that are available from all of the participating agencies this morning. So we'll start with the OLS resources and contact information. So again, I want to encourage today's attendees to visit the OLS website for educational resources on every Chicago labor law. You can watch previously recorded webinars on the BACP dedicated YouTube channel. And then here is contact information for our office for one-on-one consultations. Our phone number is 312-744-2211. We are located at 2350 West Ogden on the second floor. So there's our mailing address. And then we have 2 email addresses that can be used to contact us. So the first one is BACP labor standards at cityofchicago.org. And then we have our general outreach email, which is bacpoutreach@cityofchicago.org. I keep mentioning the OLS website. So here's a preview of the information that is available on our website. So it's leading off with an alert box informing people about upcoming webinars, such as the one that you're attending today. There'll be a Spanish version of the same webinar on Tuesday, July 30th. And then on Tuesday, July 23rd, there'll be a slightly different webinar for employers of creative workers. You have access to updated rules and regulations. Each of our labor laws has an individualized website page. You can gather required public notices and resources and educational material that I've mentioned. And then to give people an idea of how the YouTube page looks. So all of our workshops are recorded and posted, as I've repeatedly mentioned this morning. We have created or curated several playlists based on specific topics and ideas. And it's not just labor laws that we speak about. The department offers an additional array of services. So topics include business licensing, business operations, accessing additional financial resources, marketing, and more. All programs are free and open to the public, and they're taught by industry professionals, not-for-profit agencies, and government agencies. So we have webinars every Wednesday and Friday with revolving topics. With that being said, I will now kick things over to Laura.
Thank you, Miguel. As Miguel mentioned, there's various ways to be in touch with BACP and the Office of Labor Standards. We do encourage you to go to them if you have any specific questions or compliance conversations that you want to have, but we also do want to note that DCASE is offering an array of resources for you all. You can connect with DCASE staff by emailing us at culturalresources@cityofchicago.org, or you can join us at an upcoming virtual office hour session to ask us questions about this campaign, city processes, connect to resources, or to ask us any general questions you have about advancing your art projects. We also want to point you to 2 DCASE web pages. One of those is one that's been mentioned in this presentation previously. That is the Creative Work web page, where we are sharing resources that speak directly to these ordinances and law changes that we spoke on today. The second page is the Creative Worker Resources page. This is a site where we're continuously adding resources that might be of relevance to you as a worker in the creative sector. So bookmark that page and make sure that you visit it to see what additional information is provided. This is a quick preview of that Creative Worker Rights Campaign webpage. As you can see from the arrow, we do have a page within this website called For Workers with resources specific to individual workers in the sector. We've populated that page with details on the campaign and how changes apply to you. Next slide, thank you. In addition to the information that we've presented from BACP and the Office of Labor Standards and DCASE, there are a range of other resources that we want you to have access to. If you're looking for general assistance and questions, there are help desk offerings and office hours available through Lawyers for the Creative Arts, as well as the Arts Alliance of Illinois Help Desk. Several campaign partners have also offered model contracts that you may want to review as you prepare for any future projects. Please visit the Illinois Department of Labor or Chicago Dance Makers Forum to see sample contracts. If you are interested in ensuring that you are following best practices on accessibility, visit the Mayor's Office for People with Disabilities, or MOPD, or you can visit 3Arts to learn more. Last but not least, there are some helpful resources with wage or fee calculators that you may want to also reference or access. Those include the MIT Living Wage Calculator and the Working Artists and the Greater Economy or Wage. So just valuable resources to reference. We are glad that you joined us today to learn more. We are offering 2 different types of webinars, one for employers and one for creative workers. In the coming weeks, we will present these 2 webinars in Spanish. You can join us on Tuesday, July 30th for the Spanish version of the Employers for Creative Workers presentation, or on Tuesday, July 30th for the Creative Workers presentation. All of these webinars will be made available on BACP's YouTube page. We recognize that you may have a lot of questions about these ordinances and law changes and how they apply to you and your work. So this is just a summary of the emails we've referenced today so that you know how to reach out to the Office of Labor Standards, DCASE, or the Illinois Department of Labor. And we have been answering questions in the chat, but we will also be able to make some additional time now to answer any questions out loud. And so please do populate any lingering questions that you have into the Q&A portion of Zoom, and we will start to respond to those questions. I will queue up one question and see how my team members may be able to respond to these. What laws govern incarcerated workers? How do protections or requirements for those workers compare to the new labor laws being discussed here?
I can answer that to a certain extent. I mean, obviously there are you know, criminal laws. Illinois Department of Labor does not enforce criminal laws or does not get involved with criminal laws. So, I mean, as far as I'm aware, there's no exclusion for incarcerated workers for certain for many labor and employee laws. I think obviously there are some due process concerns regarding participation in a investigation or an administrative hearing or whatever the case may be, but I'm not aware of anything specific, any more protection or less protection for incarcerated workers. I do know as a policy matter, there is a fundamental, I think, unfairness for incarcerated workers to start getting access to justice. So, but legally, no, there is nothing like additional or, for example, then the definition for Freelance Worker Protection Act is nothing in the definition for incarcerated workers, right? There is a policy question. I think there's lack of fairness for incarcerated workers under all of our laws, honestly.
Thank you. Miguel, is that also the case for city ordinances? As to whether they apply evenly to incarcerated workers?
Sorry, yes, it's we're in a similar position. Nothing in our ordinances would cover an individual who's part of the penal system or incarceration system, and that they are working while being incarcerated.
Thank you. There's also a question about who would be best to contact to ask a more detailed question about whether a specific job would make somebody an employee or a contractor? What is your advice on who to reach out to first?
You can reach out to either the state or us. I do want to point out something that I did not mention during my portion of the presentation. So for example, if you're going to file misclassification as a wage theft case by city ordinance or by the city law, you are only able to file either with us or with the Illinois Department of Labor, but not both. So just keep that in mind. But yeah, I would, and Ganapati can correct me if I'm wrong. But I would, yeah, you can contact either one of us and we can refer something if it makes more sense for the other agency to be looking at it.
Yeah, Miguel's right. So dol.questions@illinois.gov would be your, so DOL.questions@illinois.gov would be your best source or best starting point in terms of questions about that, and then that would be sort of your we have people monitoring that email account, and they would guide it to the appropriate division or to legal. I may be the one answering the question, who knows? But it may go to the appropriate entities within Department of Labor, or it may go to the City of Chicago, right? So that's usually your starting point. So we do the best that we can to get these questions, to help out workers as quickly as possible.
Great, thank you. A clarifying question for the Freelance Worker Protection Act. If a contract began prior to July 1st, 2024, but ends after or ends December 31st of 2024, would this contract not be subject to the new Protection Act?
So it only applies to contracts that went into effect after July 1st, 2024. So you will have to look at the contract terms and determine what is the effective date. So I can't give legal advice, but I can give you examples where, generally sometimes a contract could say, we're signing it on May 1st, 2024, but the effective date when the terms of the contract could state services will not start until August 1st, 2024. That would be the effective date. So these would be fact-specific situations that we would analyze, but that could be one scenario. So it would be the effective date, which may be different than the signature date. So to answer that question, it would be the effective date after July 1st, 2024.
Another question related to the Freelance Worker Protection Act. My S Corp is located in Chicago. If my company is to be paid by a client with the 30 days, does that law only apply to my clients located in Illinois?
So your S Corp is located in Chicago. My company is to be paid. So your company, presumably you are a freelance worker, and you to be paid by a client within 30 days. So in order for the law to apply, first, is this company considered an independent contractor or not? Second, right, is it for services, or is it for services or goods? Sorry, services or products provided in Illinois or for an entity in Illinois. So are you providing these services or good in Illinois? Like you suppose you are a dance performing entity company, right? You perform dances or events like that. Are you doing them in Illinois, or is the client in Illinois? And is the value of the work equal to or greater than $500 in a 120-day period? So you would have to satisfy that 3-factor test. And then if that's true, then full payment is due by the due date of the contract. If there's no due date, then within 30 days. And so to try to answer your question the best that I can based on that, assuming that this company is an independent contractor, you're providing the services in Illinois, or if the entity, the hiring entity, is in Illinois. So not necessarily determinative of, it's not determinative that your clients or your whoever, like if the freelancer worker is in Illinois, but if the services are being performed in Illinois, or if they're for a hiring entity in Illinois, that would be more, that's what the law requires. And then the 30 days, that's only relevant if the contract doesn't have a specified due date.
Thank you. If a contractor has signed a contract with an indemnification, I can't even say that, indemnification clause, or a clause that stipulates arbitration and legal actions cannot be taken, does this new law no longer apply?
The law doesn't, I'm assuming this is regarding a freelance worker. So the law does not indicate that parties cannot identify, either one or the other, or that that there is no arbitration provision. Or you can have or not have an arbitration provision. The one thing I can't really give legal advice on, I can just specify the law. The law provides first of all, the Department of Labor has model contracts, right? Those are contracts that are based on the requirements of the statute. Step two is that the law, the Freelance Worker Protection Act, provides a private right of action that allows freelance workers whose rights have been violated to go to court to enforce the contract terms. So court is not an arbitrator. A court is arguing your case before a judge. So I can't get into whether or not, what I can only say is every contract is different. But for this community, look at the model contract on our website, review the act, right? And your rights, and then send a question over to dol.freelance. So I'm trying to, I apologize, I'm trying to thread the line, or thread the needle here.
Thank you, that's definitely helpful. What if an employer is found to have been misclassifying and thus underpaying employees for years? Is there a statute of limitations, and what kind of liability may they be subject to? And I think, and in that case, the question is for either Miguel or Ganapati in terms of misclassification.
So from a city ordinance perspective, we have a limitation, or we're able to go back up to 3 years, but under specific circumstances. So if in rare instances, we can go past the 3 years, depending on what the circumstances are. So was there willful withholding of information that would lead to the worker not being aware of it? But for the most part, we have an ability to go back a period of 3 years.
Yeah, I mean, statute for under the Illinois Wage Payment Collection Act, you know, if you believe that you're an employee, which makes you subject to the act, and you've been underpaid, you have to file a complaint within 1 year. And what type of liability is available, or what's available to you is, you know, underpayment, obviously what you're owed, and then damages, right? So there's underpayment owed for every month that the employer has not paid, and then and I believe the law changed to around 5%. And then there's like a 20% penalty as well owed to the department. So there are penalty and interest damages available to the worker and to the department. But the main thing is underpayment, and you have to file within 1 year of you being not of the violation.
Thank you. And so it sounds like on this misclassification and underpayment, it may be helpful for individuals to check in to see which pathway, either city or state level, might be the most appropriate for them to pursue. Is that correct?
Yeah, I think the city, they, like, for example, for minimum wage, right? City has a higher minimum wage so than the state. So Miguel, let me know if I'm wrong in any of this, but like for minimum wage, we would recommend going to the city, right? They have a higher minimum wage. I think also for wage theft, right? The city, first city of Chicago, right? It may be, I don't want to say it always the case, but it may be more appropriate to file a complaint with the city, and certain wage claims, just because I think Miguel and his team do an awesome job. So, Miguel, let me know if I'm wrong in any of this.
Yeah, no, yeah, you're correct. It's going to be dependent on the specific issue at hand, but then yeah, whether it makes sense for a worker to file with the city or with the state. There might be other issues which might also be like wage theft. So you have earned the vacation time that wasn't paid out. The state would probably be best suited to like pursue that under the Illinois Wage Payment Collection Act. If it was like earmarked as PTO and a universal bucket or vacation time, but it's really dependent on the specific allegation that comes up. And then obviously, yeah, like there might be something simple where like, yeah, if you're working in Cicero and like you were engaged in wage theft, then like there will be nothing that the city's Office of Labor Standards would be able to do for you in that case. Like if your job site is not located within the city, in which case we would refer you to the state. But those are very simple examples.
So I guess if you're confused or just unclear, I mean, you can pick either of us, Department of Labor or City of Chicago, and then we'll make sure that's directed to one or the other.
Thank you both for helping to provide clarity on that. There are a couple questions about credits, so we will tackle those via email. So if you see that changing in the Q&A section, just know we'll follow up with you on the credit question. There is another question in here about payroll. The individual asked, so before I implemented my payroll, I paid my workers some cash on Cash App or Zelle, but my real question is, what is the difference between payroll and certified payroll?
I mean, I guess I'm trying to understand this question. I'm talking about certified payroll in terms of the Prevailing Wage Act, because there's a legal definition for certified payroll records under the Prevailing Wage Act. But that's, I mean, that's for very specific industries. So I can't answer that question unless I get more context for stateside. Unless I'm missing something, which might be true. But.
Yes, that's Crystal. If you have additional details to that question that you want to share, that would be great if you pop them in there. Can somebody speak to the labor laws that govern under so youth employees, so high school students?
So the minimum wage for individuals under the age of 18 who are working less than 650 hours a year gets set by the state. So I believe that is $12 an hour now. If they're working above that threshold, then it's the state's full minimum wage, which would be $14. In order to qualify under Chicago's minimum wage, you would have to be 18 or older, aside from that subsidized youth employment program. But that's typically like only like, think of like a summer job that gets offered through like the park district or the libraries or the One Summer Chicago program. And then that's where that $15 minimum wage kicks in for a youth employment program that is in some form subsidized by a government agency.
Great, thank you. If you have any other questions, feel free to add them into Q&A. I'm just looking at all the things that have been submitted to make sure we have things fully covered. One new question, what about employees that are non-union but work in a union environment? Are they covered by the union contract or these laws?
I'm not following this question. This wouldn't be relevant for Freelance Worker Protection Act unless they are independent contractors and they meet the rest of the test. I mean, there are employers, just generally speaking, there are employers who have union and non-union employees. So that does exist. I think you would need to look at your collective bargaining agreement and your employee policies. Department of Labor does not, I mean, I would honestly, I'll consult an attorney.
Great, thank you. I think there's a couple of additional questions that are in the chat that might be hyper-specific. So for some of those questions, we'll follow up via email. Any other questions before we close up for today?
All right, so seeing none, I do want to reiterate that if you guys have additional questions, feel free to reach out to any of those contact emails. And with that being said, we'll kick things over for a final thank you to Amanda.
Thank you, everyone, for attending today. Thank you to our panelists for presenting. There are some questions that are unanswered in the chat. We will address those by email. After this session, you'll get an email from Cultural Resources, the Cultural Resources email address that has the link to the webinar, the email addresses for the question, for where to direct your questions, and the kind of like aggregated Q&A. So you'll have all of those answers as well in your inbox. But this campaign is a starting point for this initial collaboration between DCASE, BACP, our state partners, and we are still forming the resources that we're putting online and updating things as we go. And so all to say, if you have feedback, if there are questions that you'd like to have addressed, aren't sure, please be in touch with us. This is a conversation and we want to be in touch with you. And if you know others who would benefit from these resources, please feel free to share the links and other tools that are being created, and encourage any of your Spanish speaking friends, colleagues, loved ones to attend our webinars over the next 2 weeks if you think it's relevant for them. We will be in touch, but thank you again for your time and hope you have a wonderful day ahead of you.
Just we can say.